Good morning, everybody. I would like to welcome you this morning, and for those who have not attended one of our BSN events before, I would like to thank you for joining us. For those of us who have our frequent flyer cards, thank you for your continued support with these events. The County of Grande Prairie Business Support Network was created to build strong partnerships within our business community that will address common, current, local, regional workforce challenges. The County of Grande Prairie Business Support Network events are open and positive for business groups and individuals to collaborate and exchange ideas and information on current market labor trends. They address workforce development, attraction, and retention challenges as well. So the BSN is a partnership between Alberta Labor and Immigration, Community Futures Grande Prairie, the County of Grande Prairie, Grande Prairie and District Chamber of Commerce, Grande Prairie Regional College, Grande Prairie Regional Tourism, Peace Wapiti School Division, Western Cree Diversified, and International Paper. Please join us in welcoming our guest speakers, Jennifer Casely, with, what is your new name? Balanced Perspective? I got it, yeah. And Drew Pearson with KSMC Law, as they talk about COVID and vaccinations within the workplace. Jennifer Ireson has been a human resources professional for over 20 years and has been a chartered professional in human resources since 2007. She holds her Master's of Education in Adult Learning, Bachelor of Science, and is a professional home ecologist. As well as being a business owner, she is the president of the Sexsmith Chamber of Commerce. Drew Pearson has been practicing since 2018 and works in a variety of civil law disciplines, including corporate law, surface rights, estate planning, municipal law, commercial transactions, and personal injury. He is proud to help provide these services to the community that has raised him. So please welcome Drew and Jennifer. Take it away, guys.
Do you want to go first, Jennifer? No? Okay, I'll dive in then. And we'll see if I can share this. There, can everyone see my screen? Good, good. Okay. So I apologize. My slides aren't as pretty as Jennifer's, but I've got the information in there, and hopefully they'll be easy to read, if nothing else, and not too many spelling errors. So there's lots of areas of law that are engaged by COVID-19 and vaccinations in the workplace. I've sort of broken it down, and I'm going to focus on three main ones. So privacy laws, human rights legislation, and then employment claims. A lot of this is going to be applicable in a variety of workplaces, including some unionized and public or federally regulated workplaces. But to the extent that it matters, I have focused on private Alberta businesses. So that's businesses that are governed by provincial legislation, not banks, not airlines, that sort of thing, and private, so not public entities, not municipalities, post-secondary education institutions, that sort of thing. There's a few areas where we get privacy laws. The most relevant one, what I'm going to focus on this morning, is a piece of legislation called PIPA. This is the Personal Information Protection Act. It's provincial legislation. Another relevant one, though, is PIPEDA, which is the Personal Information Protection and Electronic Documents Act. That's implemented by the federal government, and to the extent that the provinces haven't regulated an area, PIPEDA is going to fill in the gaps. But for most commercial entities in Alberta, PIPA is going to be the place that you'll look for your privacy rules. In addition to both of these statutes, there is a body of common law that deals with privacy, and individuals can sue other individuals or business entities for invasion of privacy. That's not going to be too relevant for most businesses, at least at this stage. If you're complying with the rules around PIPA, you're putting yourself in a pretty good place to avoid privacy torts. And I'll mention this as well. It's a little bit cumbersome, but if you ever need to look up a statute, any piece of legislation, whether it's provincial, federal, this website here, CANLI, stands for the Canadian Legal Information Institute, is great. It's a huge free database that anyone can go on and they can search up statutes and read all the rules in a convenient way. So what does PIPA say about privacy? Well, and why is it important now? All employers are going to be collecting some information about their employees. particularly now when people are very sensitive about vaccine information and people need to collect that information. These rules are going to be very important. People are, there's a heightened degree of sensitivity, which leads to the potential for conflict, complaints, that sort of thing. And personal information, as defined in PIPA, is very broad. It absolutely includes vaccine certificates, any sort of proof of vaccination, even just the answer to the question, have you been vaccinated? That's all personal information. Any information about an identifiable individual is personal information. And if you're collecting it for a commercial purpose, then you're falling within the ambit of PIPA. You don't have to take a record. If you've just viewed the information, that's still a collection. And again, if you're doing that for a commercial purpose, whether it's to allocate workers to a certain job site, to permit people to enter your business, that's all going to bring you under PIPA. PIPA requires consent for the most part. There's a few rare occasions when you can collect personal information without consent, and we'll touch on some of that. But by and large, you need to get someone's consent before you collect that information. It can be given in writing or it can be given orally, but it should be informed. So that means that at the time you're collecting information, you'll want to communicate a few things. You'll want to communicate the reason you're collecting the information, what you're going to do with it. Are you going to disclose it to third parties? Are you going to store it? Are you going to create a copy? What services are you providing in exchange? What the reason you need that information? What services do you need that to provide? And ideally, although in practice it's a little bit more difficult, if you can give some communication about how you're going to store that information so that people are aware of the risks of their information, that's great as well. And the purpose is important. I think a lot of people miss this, and it can trip people up. At the time that you collect information, you need to explain the reason you're collecting it. And then once you've given that reason, you're locked into that for the use of that information. So if I collect someone's information to let them into my business, that's great. I can screen people and say, okay, you're vaccinated, you can come in. You're not vaccinated, I'm sorry, we can't help you. But I can't then use that information elsewhere. If I want to use that information for another purpose, I need to get consent for the new purpose. The other thing that a lot of people will miss is that you should post somewhere a company contact, a privacy officer who can respond to questions about the company's privacy policies. Often this is done on a web page, or maybe you've got a paper posted on the door if you're screening people, for example, at the door of your business. That's one of the requirements of the Act as well. One of the exceptions to the need for consent is dealing with employees. There are some situations where you can, for example, disclose employee information without consent, but they still have to be notified that it's going to be happening. So the example that I'll give for this, which may be relevant, and certainly I've heard it from some of our clients, is that certain customers, production companies, places like that, require that anyone attending their sites has been vaccinated or has received a rapid test. And it's not always practical for the employees to be conveying that information. There are situations where the employer needs to tell their clients information about their employees. They need to say, these guys are vaccinated, these guys aren't. In the normal course, you would want to get consent for that disclosure. With employees in particular, you don't need to. As long as you've notified them up front when you've collected the information that this is what you're going to be doing with it. You may disclose it to third parties for the purpose of allocating jobs, something like that. You've given them notice, and that's one of the situations where you can then disclose. You don't need to get consent every time you disclose it to a third party, as long as it's fitting within that purpose you've identified. This is important as well, the limits on what you collect. PIPA says that you shouldn't collect any more than is reasonable. And that means that maybe if you're screening people at the door, at clients, you just look at their vaccine proof. You don't make a copy of it. Maybe in some circumstances, you've got recurring clients, that might be appropriate. But by and large, public facing, a restaurant, something like that, you want to limit the extent of the collection of information, and probably you're looking at just reviewing the document. If it's something like an oilfield services company where you might need to provide copies to customers, that sort of thing, it's more reasonable to take a copy. But even then, you only want a copy of what you need. You don't want any additional information beyond what's necessary to fulfill the purpose that you have. And if anyone has questions as we scroll through, feel free to throw some questions in the chat. I think it's probably the easiest. I'll try to move through it, and we'll have some time for questions at the end, but if there's something in particular on a slide that you're unsure of, by all means, pop a question into the chat. So what are some good practices when we're dealing with privacy laws, which we all will be in the coming days? Identify a privacy officer. That is one of the requirements of the Act, and it's good to have someone who is versed in the rules so that they can respond to internal inquiries and inquiries from the public about how you're going to handle the retention, collection of information. You can post that on a website. That's a good way to do it. Social media. If it is something where you're dealing with the public a lot, maybe you have a posting about your compliance with the restriction exemption program, and you throw in the information about your privacy officer on that. If it's feasible, having a written consent is great. That makes it easier to prove things down the road. Written consent isn't necessary, and even express verbal consent isn't necessary. You can imply consent from someone coming up and showing you their vaccine card at the entrance to your business. But especially if it's something where you're keeping a record, I would recommend trying to get written consent. That's going to be, if there ever is a complaint, it's going to be the easiest way to prove that you've complied with the rules. And not only is the written part going to show that you've got consent, but it's going to show the purpose and the scope of what you're collecting. So as part of that consent, I would identify what you're collecting, why you're collecting it, how you're going to use it, who it might be disclosed to, all of those things. Only collect what you need. The Act says you can only collect what's reasonable, but practically speaking, the less personal information you're collecting, the less you have to worry about, the less likely there's going to be a complaint, and if there is a complaint, the less likely the damages will be significant. That said, there are practical considerations, and if it's going to be more efficient to create a copy, by all means do that. That's permissible. Just know that you'll want to take better care the more information that you have. And this one is important as well. This will sneak up on people, I'm sure. You shouldn't retain information longer than it's necessary. That's a requirement of PIPA, and it's another one of those practical things. If you've got vaccine records stored in your database and you're hacked or something like that, someone in the organization who shouldn't see that database gets in and sees it, you've got a potential privacy breach. So the longer that's sitting around in your servers, the longer you're exposed to that liability. So you should review from time to time whether you still need that information. And likely in these situations when the public health measures change, you'll want to take a look and say, okay, is it still appropriate that we have copies of vaccine records stored on our computers? Do we still need them? Can we destroy them? This website is great as well. This is the Office of the Information and Privacy Commissioner, the Alberta one. They've got some good guidelines, and they sort of break down the PIPA in an easy to digest way. If you do search this, the whole citation here on Canly, you'll get the full list of the rules, which is great, but it can be a little cumbersome to read, whereas the Privacy Commissioner breaks it down, keeps things a little bit simpler. Any questions on privacy before I roll on to the human rights? So human rights laws. This is another big area of law that's engaged by vaccines in particular. Human rights laws are in each province, and in a nutshell, what they're designed to do is prevent discrimination on the basis of certain protected grounds. So I've listed them here at bullet point 4. In Alberta, the protected grounds are race, religious belief, color, gender, gender identity, gender expression, physical disability, mental disability, age, ancestry, place of origin, marital status, source of income, family status, and sexual orientation. The ones that seem to be engaged by vaccination policies are religious beliefs and physical disability. So there are people who have medical conditions that make them unsuitable for vaccination. And there are people who at least are alleged to have religious beliefs that prevent them from being vaccinated. The religious beliefs haven't been tested that much in our tribunals. So we don't have a bright line as to when the vaccine hesitancy will fall within the ambit of religious beliefs. Medical conditions are a lot easier. They're going to have proof from a doctor that's going to say you should or shouldn't be vaccinated. Provincial businesses are going to be under the Alberta Human Rights Act. So again, you can look that up on Canley if you like. There's also the Alberta Human Rights Commission webpage, which, similar to the Privacy Commissioner, breaks it down a little bit simpler. Federally regulated businesses, so First Nations businesses, banks, airports, they're going to be under the Canadian Human Rights Act. When someone identifies a restriction based on one of these protected grounds, employers have a duty to accommodate that restriction. And I'll note here that the human rights legislation doesn't apply to just individual beliefs. If it's a religious belief, yes, it can engage human rights legislation. If the restriction on vaccination is coming from a medical condition, yes, it can engage human rights legislation. But if it's a political belief, for example, or just general vaccine hesitancy, which isn't tied to religion, those are not going to engage human rights legislation. And policies that have a discriminatory effect on those people are not going to be discrimination within the meaning of the human rights legislation. So when we talk about, go back a second here, when we talk about accommodating employee needs, there's sort of two pieces to that. There's a procedural aspect. So to satisfy an employer's duty to accommodate, they should go through some steps to explore what accommodation is appropriate. If we're talking about vaccination, employers should look at whether there are alternative duties that an employee can be assigned where maybe they can work from home and then we don't need to vaccinate them. Maybe they can work in an area where they can appropriately social distance. Maybe they can work for clients, customers who don't have a requirement that anyone on their site is vaccinated. Maybe they can instead have frequent rapid testing to ensure that it's safe for them to go to job sites. All of those, that's a list of 4 or 5 ways that accommodation could be done. So there's a question here, what would you ask for documentation if anyone is claiming religious exemption? Yeah, it's tough to say. We don't have great guidance from the Human Rights Commissions as to what is going to be needed. I would certainly ask for some documentation, and that is part of the duty to accommodate. When the duty to accommodate is engaged, it applies both to the employer and the employee. The employee has to cooperate to facilitate the accommodation. So it is appropriate, and it's common for employers to ask for some documents or information, if not documents, identifying what the medical condition and what medical restrictions are applicable to their employee. If it is a religious belief, it would be appropriate to ask what the scope of that religious belief is and what its source is. But the reality is whatever you get from that request, I can't tell you whether it's going to be enough for a human rights tribunal to say that, okay, that is engaging a protected ground. We just don't have a lot of great guidance so far with respect to the COVID-19 vaccines on that front. But definitely it's appropriate to ask, and if nothing else, that'll tell you the scope of the restrictions that are being claimed. So back to the duty of accommodate, you've got that procedural aspect, so you should explore those options, and you should evaluate the pros and cons of those. Just because there is a restriction that's tied to a protected ground doesn't mean that you have to accommodate it. There are limits on the duty of accommodation, and there's a few of them here. Ultimately, an employer is only obliged to accommodate some restriction up to the point of undue hardship. And undue hardship includes things, considerations of cost, business efficacy, safety. Ultimately, human rights legislation and the duty to accommodate is balancing competing interests. We've got, on the one hand, the right to be free of discrimination on these protected grounds, but we also recognize that there are safety concerns that can supersede individual rights. There are, and if we're talking, because we're dealing with private businesses, there are business concerns that can make it impractical for an employer to accommodate certain restrictions. And there are some requirements that are just necessary for certain jobs. We call those bona fide occupational requirements. The example I've given here is a common one. Firefighters have to pass a physical fitness test. That has a discriminatory effect, right? That's going to disproportionately disqualify women based on their genetics. It's going to be harder for them to complete the physical fitness requirement. And that is discriminatory. That's one of our protected grounds, gender, and it's having a discriminatory effect. It's making it harder for women to become firefighters than it is for men. But it's justified because firefighters will need to kick down doors. They'll need to chop through windows, all sorts of things, carry heavy hoses around. And they need to do those things to effectively save people. So that's an example that's justified. Another one that's common is like a hard hat. If you're employing someone who's Sikh, they'll have obligations to wear a turban, religious obligations that are well recognized, to have a turban, to carry a kirpan, the ceremonial dagger, to wear facial hair. All of that said, it's appropriate if they're working on a oil and gas site that they are required to wear a hard hat. If they're dealing with H2S, they'll be required to shave so that they can fit the safety equipment on. Those are both examples of balancing practicality, cost, safety with the right to be free from discrimination. So it's a little bit trickier when we're talking about vaccines, because we don't have as much guidance, again, from the Human Rights Commission as to when there's going to be undue hardship with vaccines. Some things could come up. If it's rapid testing, if the employer is paying for rapid testing, the cost relative to the value that's being generated from the services, that could be relevant. Safety is going to be very relevant. The Human Rights Commissions, to the extent they've given some commentary, have emphasized safety a lot. So if an employer is dealing with a sensitive population, it's going to be quicker to get to undue hardship if your employees can't deal with that population at all, because they'll put them at risk. As I said, there's no bright line so far. I'm sure there will be eventually, but we're just not there yet. What we do have is some commentary from various human rights commissions. So I'll read through these to give you a sense of where they're at. This is not ultimately binding. This is like a policy statement that the Alberta Human Rights Commission has put out. Eventually, it'll filter through the court system, and our Supreme Court will give as much guidance as they can on this issue. But that could be a year from now, who knows? This is what our commission has said. Getting a COVID vaccine is voluntary. However, the requirement to show that a person has been vaccinated before they can enter certain businesses is permissible under the Human Rights Act, as long as those who have a valid exemption are reasonably accommodated. For example, a business does not necessarily have to accommodate a person who's not vaccinated by permitting them to physically enter the business, office, or establishment. Other methods of accommodation, such as curbside pickup, would also meet a business's human rights responsibilities. This is kind of the key point here. During a health crisis, such as a pandemic, the rights of those who are unvaccinated due to a disability or other protected ground must be balanced with the health and safety of the general public. Using accommodation is one way to strike that balance. And employers must accommodate employees who may not be able to comply with the vaccine requirement. For example, an employer may accept a negative PCR test or accommodate an employee by permitting them to work from home. In each case, the employee must establish one of these protected grounds for why they can't comply with a valid requirement. In BC, again, this is not strictly speaking binding on Alberta corporations, but it does give us a sense. They talk and they refer to each other. So it gives us a sense of where the human rights tribunals are heading. It's the position of the BC Human Rights Commissioner that duty bearers can, in some circumstances, implement a vaccine status policy, such as proof of vaccination, but only if less intrusive means are inadequate for the setting. Duty bearers must accommodate the diverse needs of their employees and the public to the greatest extent possible. If vaccination status policies are necessary to address specific safety concerns, duty bearers must seek to accommodate those who have a reason why they can't be vaccinated. And those accommodations should be based on the individual needs of those involved, and they should be as easy and unburdensome as possible. In Ontario, COVID-19 vaccination remains voluntary. The Human Rights Commission takes the position that mandating and requiring proof of vaccination to protect people at work or when receiving services is generally permissible, as long as protections are put in place to make sure people who are unable to be vaccinated for code-related reasons, so protected grounds, are reasonably accommodated. Upholding individual human rights while trying to collectively protect the general public has been a challenge throughout the pandemic. Organizations have to balance those rights. They're recognizing that there are valid reasons, protected reasons why people may not be able to be vaccinated, and that's going to trigger the duty to accommodate. And we're looking at the circumstances of the businesses. So safety sensitive businesses, they're going to more easily implement restrictions and be able to justify them as opposed to less sensitive workplaces. So what does that all mean? What should you do? Unfortunately, this is one area for sure where there's no clear rule as to what you should do. It's a balancing act. And you're going to need to consider the specific requirements of your workplace, the type of services that you're doing, the people that you employ. For sure, you should be prepared to investigate accommodation. So if someone comes to you with an exception as to why they can't mask, why they can't be vaccinated, why, whatever policy that you've implemented, if it's a rapid testing, why they can't do that, why they can't attend work in person, anything like that. If it's engaging one of those protected grounds, you'll have a duty to accommodate, and you need to do the work to fulfill that duty. So you should explore what options are available. Is there some other role that they can fill? Is there a less invasive or intrusive way to ensure that people are safe? And explore the pros and cons of that. See, how much is it going to cost you to implement this accommodation? Is it going to interfere with your operations? Are things going to slow down? Is it going to be a problem for communication, employee morale? All of those sorts of things are relevant considerations. And once you've done that work, once you see what the options are, you've got the cost-benefit analysis, then you make a decision about, okay, is accommodation reasonable? Is it something that we can do? If it is, the duty to accommodate is going to say, yes, you should accommodate. If it's not reasonable, if the costs are just too much, then you may be in a position where you have a legitimate, justifiable, discriminatory effect. And that's when you may not be able to accommodate, but be prepared to show your work in getting there. If your policy is challenged, you haven't, reached accommodation, someone might bring a human rights complaint, and you're then going to have to show all of that work. You'll have to show that you explored what the options were. You'll have to show the calculus that got you to the point of saying, we can't accommodate, it's going to be undue hardship, and that there aren't options available to us. Any questions about that?
Drew, we do have a question in the chat.
Okay.
I don't know if you saw that. So what would you ask for documentation, if any, if someone is claiming religious exemptions?
Yeah, so on that, there's no, it's tough. I couldn't tell you what a human rights tribunal is going to say is a valid religious exemption or not. It's an area that's developing. You can ask for documentation. I think it's appropriate to in most circumstances. It might be a letter from a religious leader or even just some policy statement that's been posted. In general, the duty to accommodate is going to require that the employee works with the employer. So works with them to communicate the scope of their restrictions, works with them to accept reasonable accommodation when it's offered. So it's fine to ask for information about the scope and the source of restrictions. The trick comes when you're evaluating to say, okay, is this sufficient to engage human rights legislation? That's tough, and I can't give you too much guidance there. Probably best to err on the side of caution and assume that it does, see what accommodation is available. And then, if you can't accommodate, just know that you would have some argument potentially to say that the source of the exemption isn't actually engaging one of the protected grounds. So moving a little bit away from the human rights side, every employee, almost every employee, also has some common law contractual entitlements surrounding the termination of their employment. So we can imagine a situation where a few things come up. One, a policy has been implemented, a vaccination policy has been implemented, or your clients have implemented the vaccination policy and it's not being complied with. Can you then terminate that employee? What does that look like? Or two, it's led to some changes in the workplace. Maybe employees are doing different duties than they were before. Maybe you just don't have as much work to give them. Most of your clients are requiring people to be vaccinated, and so you've got fewer opportunities to put unvaccinated people to work. What does that look like? Can you terminate those people? Do they have claims against you? It's again very tricky. The first thing to note is that unlike the human rights legislation, employment claims are not tied to any protected ground. So here, it doesn't matter what someone's reason for not being vaccinated is. It's just a question of, do they has a contract of employment between them been breached in any way? I'll just note as well, this is going to be more focused on private, so non-unionized, non-public employers, and again, provincially regulated, so not the banks, not the airlines. Generally speaking, any employee in that setting can be terminated for whatever reason or with no reason at all, provided that the termination isn't based on their age, race, religion, that sort of thing. Again, that's going to be, if there is one of those protected grounds in play, that's going to engage human rights legislation. But for any non-discriminatory reason, you can just let an employee go. And all they're entitled to is notice. So statutory notice under the Employment Standards Code, depending on their length of service, it caps out at 8 weeks. And also contractual notice. And the contractual notice is the trickier part. It can come in the form of a written agreement or even a handshake deal. If at the time that you employed someone, you told them, if I'm going to terminate you, I'll give you a week of notice per year of service. That's fine. That's exceeding the minimums. Great. That means it's potentially enforceable. And if they've agreed to that as a part of their employment, they'll have a claim for that week per per year of service as notice or pay in lieu of notice if it's not actually given. But more commonly, that's not thought about. It's in my experience anyways, not as many employers as should will have termination clauses in their employment contracts. And certainly if it's a handshake deal, it's pretty rare that they're going to raise that and discuss it at the time they're hired. So the default, if there's nothing to the contrary in a contract of employment, the default common law rule is that employees are entitled to reasonable notice. And I won't go too far into how to calculate that, but you should know that reasonable notice is typically quite a bit more than the statutory notice. At the very high end for the senior long-term employees, there's sort of a soft cap of 24 months of notice. For most employees, it's going to be less than that, but it can be quite a bit more than the minimums under the Employment Standards Code. One big exemption to that notice requirement. So by default, you're required to either give that working notice. If you don't give working notice, someone could sue you for damages, what they would have been paid had they been given working notice. Just cause is an exception. If there's just cause for terminating an employee, then they can be terminated summarily without any notice at all, and they won't have a claim for pay in lieu of notice. The question that comes here is, okay, if there's a vaccine policy, it's not being complied with, is that going to be just cause? Can I terminate that employee without notice, and will I avoid a lawsuit? It's not 100% clear. The just cause, there's no cases yet that have really laid out exactly whether that's going to be cause or not. The general consensus is that it's going to be a tough argument to make. Just cause in general is a pretty high standard, and there's a lot of deference given to employees. The courts are somewhat reluctant to provide that that an employee doesn't get some compensation when they lose their employment. Things like on the high end, if there's workplace violence or theft, any substantial theft, serious dishonesty, those can be a sort of one strike you're out things. If there's that kind of misconduct, employers can be in a situation where they can terminate with just cause. On the low end, if it's showing up late to work, poor performance, that's a lot tougher, and employers are generally going to have to give the employee every opportunity to improve, give them multiple warnings, notices, and even after all of that, it still might not be just cause, depending on the circumstances. And then there's this huge gray area in the middle. And non-compliance with vaccination policies seem to fall somewhere in there. We don't have any great guidance as exactly when that's going to be just cause or not. But I would err on the side of caution and assume that it's going to be a pretty tough argument if you are alleging cause, and probably a good chance of litigation either way, just because we don't know the answer yet. If it is a situation where you might need to allege cause, it's going to be typically easier when there's been a very clear communication of the policy. So it's well documented, it's consistently enforced, it's been communicated to the employees, and also progressive discipline. So it's not, if it's a one strike you're out thing, that's going to be a harder argument to make. If the employee has been given opportunity, time, resources to improve, and they consistently fail to comply, that's going to put you in a little bit better case. But even then, it's not a sure thing. The other thing I'll talk about is constructive dismissal. So this is a situation where the employee is not expressly terminated, but they can still have a claim for the statutory minimum notice, contractual notice as well. Constructive dismissal comes up when most commonly when there's a unilateral change in the terms of employment. So if my boss cut my pay in half, and I'm doing the same work, the courts say, yeah, you don't have to quit and not get anything in that case. That's effectively, they've effectively dismissed you by making that change. I can then resign and I'll still have my claim for notice. In the context of vaccines and COVID, there's some risk of this. If people's duties are changing because they can't do the duties they did before for safety reasons or client requirements, that includes some risk of constructive dismissal. If I all of a sudden am doing something that I'm maybe not trained for, or I'm doing more work for the same amount of pay, or maybe I'm getting fewer hours. My pay is decreasing overall because there's just not as many opportunities for me to work. Those are all circumstances where constructive dismissal can be an issue. And it's tough. Again, it's a balancing act. There's no way, well, there's no good way to completely avoid the risk of constructive dismissal. By way of guidance, changes in compensation tend to weigh fairly highly when we're talking about constructive dismissal. So, for example, if there's a reduction in pay, that's commonly going to be grounds for constructive dismissal, if it's a pay of any significance, and also if it's not the kind of contract where you bargain for variable pay. If it's a change in duty, something of that sort, it's going to be a lot more of a gray area. The scope of the change is going to be relevant. Not all changes will result in constructive dismissal, but substantial changes that aren't contemplated by the original employment contract do carry that risk. Things like incentives and encouragement of vaccination is not likely to result in constructive dismissal. That's more of a perk. There's no downside to that necessarily. So it's going to be a hard argument for someone to say that they're constructively dismissed because of those policies. One good way, if you have the ability to minimize liabilities for constructive dismissal, is to give notice. If you've given notice ahead of time that a change is going to be coming in, that works like just as if you've given working notice of termination. So to the extent that you've given notice of a change, if someone then alleges that they've been constructively dismissed, the notice that you gave is going to reduce the amount of pay in lieu of notice that you would otherwise be required to. Unlike the human rights complaints, it's not, there's no requirement that they can be reinstated, something like that. All they get is some monetary damages to compensate them for notice, and you can reduce those monetary damages by giving the actual notice. And if you are potentially going to be alleging cause, make sure that your policies are clear, consistently enforced, and that you use a progressive discipline policy to enforce them. All right, some final thoughts. I'll breeze through these pretty quickly. You can follow all the rules and still be sued. Just know that. The fact that you put yourself on solid legal ground doesn't mean that someone isn't going to sue you, isn't going to bring a human rights complaint. Having open lines of communication, relationship management are going to be the best ways to deal with that, but you can never completely avoid the risk. These notice of liability forms that are floating around Facebook are nonsense. They don't, all the ones I've seen don't mean anything. They're silly, but don't sign them because, I haven't read all of them. There could be something in some of them that has the potential to form a contract. So don't sign them, and they're silly. If you're thinking of using them, they're just pseudo-legal nonsense. In general, don't sign anything, including those forms that you don't understand. Like I said, maybe there's some nugget in there that could be binding. A lot of them will say things like, if you don't sign this, you're automatically consenting to it. That's bogus as well. A contract is a voluntary agreement. You can't have a contract unless there's been actual acceptance of the terms. Charter, a lot of people are saying things about the charter rights. That's not applicable to private entities. The charter applies to government. So, oops, I've broken it. The charter rights are not applicable to private businesses. Human rights legislation, yes, but the private entities don't have an obligation to comply with the charter. There could also be occupational health and safety violations. So at the least, you should be complying in your workplace with the public health rules. If you permit harassment in the workplace, in general, that can be a violation of occupational health and safety rules. And if it's harassment based on one of those protected grounds, so someone's being harassed because they've got a medical condition and can't wear a mask, that could be a human rights violation as well. If you're in a unionized workplace, you'll want to refer to a collective bargaining agreement. A lot of this is going to be applicable to you, with the exception of the employment claims, but you'll have likely some additional requirements in your collective bargaining agreement, and you should probably talk to counsel about that. And I've harped on this a few times, but if it's a public entity, there are some different statutes that apply to municipalities, post-secondary institutions, that sort of thing. And if it's a federal entity, different statutes as well. but the common law claims will largely be the same. All right, I think I didn't go too long, and I hope I didn't have too many spelling errors. Any questions before I hand things over to Jennifer? I think we'll probably have some time to chat at the end as well.
That was really good information, Drew. Thanks.
You're welcome. I'll let Jennifer take over then. Thanks, guys.
All right. Just give me 1 sec here, everybody. Okay, if a couple of people just want to give me a nod if they can see my presentation. Yeah, perfect. All right. So yeah, welcome. And I would like to thank Drew for going first and talking. And my heart was just a flutter because a lot of those words that Drew uses, it's my language, it's my world. So I was very excited to hear all of those words being used outside of my office. It was really nice and refreshing. So I just wanted to thank the County of Grande Prairie Business Support Network for inviting me to speak this morning. Love attending the events and getting to share information with everybody. And as some of you noticed, Hetty stumbled a bit with my name this morning, and that's understandable. So for those of you not in the know, I'm in the middle of a personal name change and a company name change. So I was recently married, and so I've decided to take my husband's last name, not that it's any easier to say or spell. And so I also have decided to incorporate, and I'm going with the name change there. So I'm feeling a little bit not sure who I am some mornings when I wake up. And if you ask me what my name is, it depends on if I think about it before I respond. So. All right, so as Hetty said, I am a HR professional. I've been doing this for about 25 years, although COVID, of course, is new to me, just like it is to everybody else. One of the things that I wanted to go over before I got into some of the policy stuff that really excites me anyway, is some of the supports that are still available to your employees if they are sick or having COVID symptoms. So at the moment, the Canadian Recovery Sickness Benefit is still available to employees. So if they're quarantining or isolation, or if they themselves are sick with COVID, but it's only available until October 23rd. The government has not said yet whether or not they will be extending that. So we're not sure what's going on with that one at this moment in time, but that's through the federal government. The other option, of course, is potentially for employees to go on unemployment sick benefits. And of course, you would have to check with your doctor and check with EI to see if someone is eligible for that. But that is something that is out there and available because not all companies offer paid sick leave through their organization. So the Alberta government has put in a couple of supports for employees during this time, and those supports are personal and family responsibility leave. So if someone in your family is sick and you are required to take time off in order to, get them back to a healthy, active lifestyle again, then you are eligible for that type of leave. And then at the moment, we still, of course, have the COVID-19 leave. These are not paid leaves that the government is providing, but what the government is providing is that the employer is required to hold the space of the employee who takes time off under these leaves. So you have to guarantee them their spot when they come back. You can't just say, oh no, sorry, you took off to take care of your kids while they were sick with COVID and we filled your role and too bad. So you have to save that spot for them when they come back. Some of the other supports that employees and companies might have available to them is company sick leave. And I know every company is looking at this a little bit differently. Some are able to offer paid sick leave, some are not. And if you can't offer paid sick leave to your employees, still have conversations with them about, what your expectations are around them being off on sick leave, what that looks like, how long a time period, and what kind of information you might need. And when. Another option for employees who have contracted COVID through their workplace is that WCB would actually cover them during that time that they're off recuperating from COVID. So again, it would be something that would need to be proven, and there'd need to be some tracing, go back, and it really would also depend on the field. But some of the eligible employees out there would be anybody in a healthcare position, obviously would have definite, increased access, or not increased access, increased exposure, sorry, to COVID, restaurant staff, hotel staff, anyone who's sort of in a frontline position, retail staff, where they might be in touch with people who are, testing positive for COVID. And if they do contract it through work, then they're potentially eligible for WCB. So that's a nice thing to look into if you do have an employee who is off with COVID and you don't have a sick leave policy that's able to cover them. Of course, some companies also have short-term and long-term disabilities, so that is something that you may want to look into if you do have employees who are off with COVID, because not everybody is 14 days and recovered. We're finding that some employees are tending to be off for quite a significant period of time, depending on how serious the illness is with that person. So just a few things that you want to look into as far as being able to help support your employees with COVID if they do become sick. So in my house, because we have a British twist on everything that we do, we're going to talk about having a jab policy instead of a needle or a vaccine policy. We're going to have a jab policy. So a lot of companies are talking about actually bringing forth a vaccination policy. So they're like, yep, we want to do it. We want to bring it in. We want to make sure that everybody's protected. So as a company, we feel that everybody should be vaccinated. So if this is, excuse me, if this is the decision that your company is making, and you've said, yes, this is what we want for our employees, then we need to look at a number of different areas. And of course, Drew talked about, privacy, and he talked about human rights and all those aspects of it. And definitely we need to consider those. What I'm going to talk about is sort of the basis of what needs to be in that policy and what some of the other areas are that you want to consider. So of course, most policies will have a purpose at the beginning. So why are we asking our employees for this? And the purpose in a lot of cases is going to be that, our company cannot continue to work if our employees are not vaccinated, because maybe we have a lot of oil and gas contracts or contracts within long-term care facilities or in the hospital, and our employees are not going to be allowed onto those sites or in those buildings if they're not vaccinated. So that could be the sole purpose. The purpose also might be that we believe in, taking care of the general public. And so by having all of our staff vaccinated, we feel that this is the best move for our company. So let the employees know why you're implementing this, and then get on to the next little bit. So definitions. We think that we understand all the words and terminology being floated around nowadays, but it definitely doesn't hurt to put those definitions into that policy. What is a, health pandemic? What does it mean when the government says that we're in the middle of this? What does COVID-19 actually cover? Things like that. It's good to put those into that definition area so everybody knows exactly what we're talking about, and so that we're not using definitions that we found on Facebook that we think might be what these things really mean, because Facebook isn't always correct for some reason. And then timelines. So if we are going to introduce something like this, Drew mentioned, constructive dismissal and dismissal of employees, and we need to provide notice. So we are going to provide notice of bringing in the policy and what the policy is going to involve. The timeline around that is completely up to you. I'm recommending at least a month, if not potentially longer, because if someone doesn't have the vaccine at this moment, we are expecting them to get 2 inoculations and 14-day wait until they're fully inoculated. There is time in between. So we need to sort of, you need to have the first inoculation within 30 days, or you need to, have an appointment booked. You need to figure out what exactly you want that to look like for your company. And then make sure that you have a reasonable time frame set for that. And that's for current staff. Then when we're hiring in the next little bit, as we start to continue to bring on new staff, and I know a number of retail outlets out there are going to be bringing on additional staff over the Christmas holidays. what are we going to put around those staff as far as them being able to come on to our job sites with the vaccine? Are we going to require it from day one? Is it something that we're willing to wait a little while on? You know, do they have a week or 2 weeks to prove that? And so again, that's something that you may need to consider. And it might be different for Christmas retail staff versus someone who's coming onto your company on a full-time basis going forward. So those are a few of the little things that we want to, consider when we're looking at this policy and whether or not we think that this is the best thing for our company. So once we've covered some of that, of course, we want to have some procedures around what this all looks like. You know, how is the information going to be collected? Who in the organization is collecting it? Who's going to have access to it? What does it look like? You know, is it a form that we're sending out? Is it an email? Is it a walk by and we say, hey, can you show me this? What kind of proof are you requiring? And what does that look like? Is it just a, yes, I've got it, and people go check, okay, that's great. Is it that you actually have to show your new government, wallet-sized vaccine proof, which isn't wallet-sized, but what kind of proof are you looking for as a company? And are you going to accept anything else if an employee comes forward with something else? So Drew mentioned a lot about, privacy. And again, this is definitely private information. We want to find a way to store it and limit who potentially would have access to it. So a lot of companies will have a payroll person who has access to a lot of that benefit information anyway. Maybe that's the right person for it. If you don't have HR, maybe it's the owner of the company. We need to figure out who is going to have access to this and how they're going to have access before we start. So these are all the different items that we want to consider when we're looking into our policies. So another part of that policy that you might want to consider is the disciplinary part of that policy. So if they won't follow the process, if they won't follow up with getting their vaccinations and we're requiring it, now what? So you can have this done in two ways. So one way, you can have a separate disciplinary policy and you can follow your traditional disciplinary policy, or if you want to, you can put it in specifically into this policy as well. And maybe you want to do this a little bit different. It's up to you. There's multiple ways that you can look at it, but it is something that you want to consider. So my recommendation would be to have your separate disciplinary policy, follow it as per normal. And whatever that looks like for your company, that's what you need to follow with this. So some companies go with the traditional, verbal, written suspension, termination. I'm moving more and more of my clients towards minor and major and then critical incidents. And then we define what that looks like. And then based on that is what happens with the disciplinary action. As long as you are being consistent with your employees and applying this policy, that will show up better if you ever end up in court or if you ever end up in a human rights tribunal. You want to make sure that you're applying this policy consistently to everybody. So if your relative works for you and they don't want to get vaccinated and you're like, yeah, that's fine, we just won't tell people, or we won't worry about it because you're the owner or the cousin's owner, but we're making every other employee follow it and we're applying it to them, that's not going to show well if we end up having to, go in front of a judge or go in front of a tribunal and say, well, this is what we were doing. So we need to make sure that we're going to apply it consistently to all of our staff and anybody else that walks in the door, if that's what we've defined in our policy. So we really want to make sure that that disciplinary policy is in place and that it's something that we're using consistently. So disciplinary for the COVID vaccine doesn't need to be different than it is for other items. We can go ahead, write our policy, give our employees notice that in 30 days or effective December 1st, you will have to have this. And if you don't, this is what's going to happen, right? So of course, you'll get your verbal warning. That will give you some additional time to get that. And then we just continue on with writing employees up and letting them know what our expectation is around that. If you don't have a disciplinary policy in place, you should probably think about getting one soon. For me, training is a critical part of any policy. It's great. People write policies all the time and they toss them out there, or they post them on the intranet or wherever the company has them in a binder at the back of the lunchroom. But for me, the next critical piece in having that policy is training your employees in that policy. So what does the policy say? What are our expectations as a company? What happens if you don't follow the policy? And then having a sign-off sheet. So you want the employees to acknowledge it. You want them to show that they've understood it. And in order to do that, one of the great things you can do is to have them write a simple test, right? So, a few questions that come from the policy directly, have the employees answer it once they've had an opportunity to review the policy and ask you questions. And then that's just a little bit of documentation that you can put into their files saying the employee received it on this date. They had 30+ days in order to comply with it. We told them exactly what was going to happen if they didn't. They read through it, they signed off that they understood it, they passed the test. And so as an employer, we're doing everything possible that we can to CYA. It's a very politically correct HR term that we use on a regular basis. If you don't know what it means, I'm not going to explain it during this Zoom call. So we want to make sure that our employees are well aware of how this policy is coming in and what that means. It might be also a good idea to have a separate training session for any of your supervisor managers so that they're aware of how important it is that they are following this policy and making sure that their employees are following this policy. So that's an important part of training. And as Drew mentioned, exceptions, exemptions, and accommodations, there's always going to be someone who doesn't fit into our mold, and we're always going to have somebody who's going to need some sort of an exemption or an accommodation. And that's okay. We're used to that. We make exemptions and accommodations for employees all the time. COVID is just putting a little bit more pressure on us in some ways and trying to figure out what that is. So again, back to what kind of proof are you going to require if somebody says that they can't get the vaccine? So the question came up before about, if it's a religious exemption. And so in my line of work, typically if somebody was to say, I'm not able to work on this day because of my religion, we would ask for proof of that, right? So it might be a letter from the head of the church or the organization, the religious organization that they're involved with. It might also include that this person is a member in good standing within that organization and attends on a regular basis. I would hate to think that people would just go to a religious leader and ask for that type of letter, but at the same time, I've been doing this for a long time, and I'm sure people do that. So we want to make sure that we're covering ourselves with that and let your employees know what that proof looks like, right? So I would actually put some of this into your policy around exemptions and accommodations. So, we will exempt employees who are covered through, reasons under human rights. And then this is the kind of proof that we're looking for if that does come up. Be prepared, though, as things go through the court system and through human rights, that may need to change based on what they are saying is acceptable and is not. Let people know that if you do need to have an exemption or an accommodation, what the timeline on them providing that proof to you is so that they're not dragging their feet and just not getting you that information. Let them know what happens if they don't meet that timeline. So if I say, I have a medical exemption and I'll bring you that doctor's note and they haven't met the timeline, what are we going to do? And if you clearly outline what's happening, then again, you're a little bit more CYA, so you're covered and it's very clear and everybody is following the same rules and regulations. So what type of accommodations do we need to make for this person to be able to do their work? Is it as simple as, okay, you can work from home, or is it not? And again, because I love policies, and anybody that knows me knows that I really have a thing for policies, I would like to define that in the actual policy. So what I would do is I would go through the different types of rules within your company and organization and figure out which ones you can put into different categories. So can these types of roles work from home and be accommodated? What positions are not able to work from home? And if they can't work from home, they have to stay at work. Can we accommodate them with some sort of proximity? Are we going to enclose them in some sort of bubble so that they're working that way? What are we able to do so that they're not in direct contact with employees or customers and able to spread the virus that way? So what about positions that are required to visit other businesses? So if I'm a salesperson and I'm going out to different businesses, or if I have to go out to different job sites as a contractor, what is the expectation on that end? And again, clearly identify that to your employees. And then we have, of course, positions that are able to socially distance during work hours. And are we able to accommodate that for them? And if we are, great. But then we also need to think about what are we going to do on breaks and during meetings. So traditionally, I'm thinking of the shop, right? So the guys are out in the shop, they're doing their work as mechanics. They're able to socially distance while they do their work. But what happens then during coffee breaks, or if we have to have a safety meeting, are they then going to be able to socially distance? Are we able to accommodate that? What does that look like? Because there's not many mechanics who are able to take their work home and do their work from home. The same thing with a bank teller. If a bank teller is not able to get vaccinated, probably don't want them taking that cash box home and helping people out of their house with the money. So are we able to, put up additional barriers, have people working, farther away on either side of them? What can we do as a company, and what are we willing to do? As Drew mentioned, as a company, if you are going to make some accommodations because someone's requested it, make sure that you've clearly listed out what you've done, what you've looked into. And I would actually ask the employee to help with that process. So if they need an accommodation and they're, saying, okay, I need this accommodation, I can't get a vaccination, because I would involve them in the process, right? How do they think the company can work with this? How do they think you should be able to handle these things? And what are their suggestions around this? And that will also, I think, help with greater understanding from them on why you're making some of these requirements. Outside of the that particular jab policy, I think it's time to take a look at some of the other policies and documents that we have sitting around the office and see if they're up to date as well. So some of the other recommendations and revisions that I'm suggesting you make are around health and safety. So lots of companies have health and safety policies in place, but does it mention infectious diseases in it? And if not, maybe it needs to start mentioning infectious diseases. If you have a COVID-19 policy that you implemented in March or April of 2020, it probably needs to be updated. I know we've gone back and forth a few times now with, mask, don't mask, this is what we're doing, this is not what we're doing. It's great to have an up-to-date COVID policy on that. It's great to have the different steps and stages in it, and then let employees know what step and stage we're at so they know what section of that policy we're following. A number of people already have vaccination policies, or they have a vaccination piece in their employment agreements. And so if you do already have that, check and see, do you list them, or do you just ask for a copy of their vaccination records? And if so, what did that look like in the past? And let's just continue to apply that going forward. The other policy that I strongly suggest everybody have, and you're supposed to have at this point in time, is a bullying, discrimination, harassment, and violence in the workplace policy. And this policy came into effect in 2018 of June. Occupational Health and Safety said that every company should have one of these. And right now, especially during the last 18 months with COVID, it's been even more important to have this, because there's been a lot of bullying going on within the workplace because of the two sides of the vaccinations, and this is, government conspiracies and all that stuff. So it's important to have this policy in place and to let people know, within your organization, that we will not stand for bullying or harassment or discrimination against our other employees. We won't stand for it coming from clients or customers. We won't stand for it between staff. Let them know where you stand with all of that. If anybody doesn't have one, I'll just put a little pitch in. I have a free one on my website. Please go and download it, because I really want everyone to have that. Your disciplinary policy, does it need to be updated to include some of this information around COVID and the vaccinations? Just take a quick look, see if it's up to date, see if you need to add that to your policy. What about changes or updates to your hiring policy? When are you going to let new employees know that they will need or will not need to be vaccinated? Are you going to put it in your job ads that we are now a vaccinated workplace and we require all of our employees to be vaccinated? Or are you going to tell them during the interview? Will it be in the employment agreement only? And if it's only in the employment agreement, we may want to also attach a copy of our COVID-19 or our jab policy to that so that they know and they're aware of what they're getting into before they sign the contract and before they start work. Providing this document and information to them before they start work means that they've had an opportunity to review it before they feel the pressure of it being their first day of work. So you want to give it to them before they've actually resigned. If they're in that type of an environment right now where they're working, it's best to give it to them before they resign so that they have the option to keep their current employment rather than sign on with you. The problem with giving people these types of things on their first day of work is that most of the time they've given up another job, they've given their notice, and now they're unemployed if they don't accept your job. And so now they're going to sign this under duress, and that can backfire on you down the road if it is somebody signing something under duress. Your sick leave policy, again, does that need to be updated for COVID? Do we need to relook at how this is affecting people? I know that some companies, they introduce sick leave and they're like, we're so happy our employees have this. And then COVID came and people would go into isolation or a quarantine, and then they had no sick time left for the rest of the year. Is there a different way of looking at that? Can you break it up over the years? So instead of accruing it, at the start of the year, maybe it's a quarterly thing, maybe it's a monthly thing, so that they still might have a few days later on in the year if they get sick for another reason, they're able to access some of that. Personally, I would rather have half a check than no check at all if a company is providing sick leave to me. So something that you might want to consider is a little bit of that balance and sort of helping your employees out with that. As Drew mentioned, you should have an employment agreement. As an HR person, I'm begging you to have employment agreements for all of your hires, please. And that should include things like your COVID policies, right? This is what we're requiring, of our staff. We're requiring vaccinations or not. It's the same as asking people, in your employment agreement to have a criminal record check or to provide a copy of their operator's license. These are the things that we have to have in order for you to maintain or get employment with us. So it's important to have all those in there, just as it's important to have that termination clause in there. It's also something that a lot of companies didn't have in the past, is that temporary layoff. And you should also have that in your employment agreement, that we may need to do a temporary layoff. And a lot of companies didn't have that in their employment agreements before. And so when they were doing temporary layoffs during COVID, it was a little bit dicey whether or not they should be. But if you put that in there, it will help with that situation if it does arise. I'm knocking on wood that we never get to that point where we're having to close our doors again and temporarily lay people off. But, better safe than sorry is sort of how I like to look at these things. The policy manual, again, just update, make sure that everything's current in it, because if it's not, if you haven't updated that policy manual in 5 or 6 years, it's probably not going to hold up, right? If you're actually getting people to sign off on it, because things have changed, the world has changed a lot since then. And so you might want to make sure that you go through, make sure it's up to date and sign it off. And then make sure that you're doing that on a regular basis. So we are now in, the province of Alberta declared, that emergency status not too long ago. That's going to come off at some point. What are we going to go back to? And so it's great to have all of that in our policies. Make sure that whenever an announcement like that comes up, we look at some of those key policies and we go, okay, do we need to change this? Do we need to update this? Is this one now we're going into part B? And so all of our employees are sent a notification that, as of Monday, according to the government, we're now following these rules and regulations at work, be that masking, be that social distancing, be that everybody who can work from home should work from home. So make sure you review that on a regular basis. And now the fun part, of course, managing the expectations of the employees and the engagement of our employees around the workplace. So I love employee engagement. I love making sure your employees are engaged, but it's been a rough time for everybody with COVID. It's been super hard on a lot of people trying to figure out what to do with their teams. They've got people working remotely. They've got people in the office. They've got people on one side of the vaccine. They've got people on the other. And it's been a really difficult time for everyone to keep that engagement in their employees up. So we kind of want to look around, how are our employees feeling now? Do they feel a little bit settled in the last little bit? Things have sort of, this is our new status quo. We wear a mask. We, constantly are washing our hands and using hand sanitizer. But do we feel like we're starting to come out of this a little bit? And if so, what's the mood and atmosphere in the office right now? Do you think implementing a policy like this is going to be a positive or a negative change? For some companies, most of the employees are already vaccinated and they're out there loud and proud saying, yeah, I'm vaccinated. I don't care. Ask me about it. I'll tell you. And some people and some workplaces are very much on the opposite side. Businesses have said, we don't want to know. We don't care. We're not going to implement that. And so that's their choice. But you need to sort of find out where your office or where your business in general sits with that. Some people are going to be very disappointed if a company does implement this type of a policy where you must be vaccinated, and then their work wife or their work husband leaves because they're not going to keep up with the vaccinations. And you need to be prepared for staff being a little bit disengaged during this process because they know that some of the people that they've worked with and worked closely with over the last number of years are now leaving. So that's something that you need to watch for. The other thing we really need to watch for is that negativity. So the negative Nellies who, even though they're vaccinated, they're going to grumble and complain the entire time about it because, well, I was forced to get vaccinated or I was going to lose my job or I had to do this in order to go buy groceries, whatever way they're going to talk about it and twist it. So we need to watch that in the workplace because that will really drag the rest of our team down and really make everybody feel as though, well, what's the point? This isn't worth it. And so you may want to pull these people aside, have some of those discussions around that. I need you as a cheerleader. I need you backing me up. I don't need you, having this discussion at work. And, I recommended the other day, we were talking about engaging employees at the workplace. And we thought about, instead of having a swear jar, where every time somebody swears, they have to put $1 in because who doesn't swear now and then? What if we had a COVID jar? So every time somebody mentioned the word COVID or vaccine or something, they had to put $1 in the jar. And then at the end of the month, we can, have a party, buy a bottle of wine or more, whatever that looks like, right? Try and engage employees into focusing on the positive. So what can we do at the workplace to bring all of our employees over to the positive side? So yes, we are asking you to get the vaccination. No, you may not be entirely happy about it, but we would like you to focus with us on the good that this is going to do. So the good might be, that we can keep our doors open. The good is that we're allowed to have more people in the store, more people in the restaurant this way. Whatever that looks like, let's try and focus on that positive. At the end of the day, as a business owner, you need to decide what is best for your business and what's best for your company. You may lose some employees over this, but you also might gain some employees over this. I know last year when we were watching companies out there decide if they were going to make people mask up before coming into their establishments or not, this was before it was made mandatory. Lots of companies were posting, we are going to do this and we're going to ask for masks. And then some were like, we're not going to. And it was, people were equally going to each side of that, right? Some people were going to support businesses that were saying, yes, we would like you to mask up. And some people were equally going to support the companies that were saying, we don't need you to mask up. So if you are concerned that you're going to lose some of your employees over this, let's take a step back and let's look at what we can do to help them and to support them. Talk to them, right? Why don't they want to get vaccinated? What's holding them back? Is it fear? Is it, that they're not sure what's going to happen? Is they don't know, should you bring in a public health nurse to talk to them about it, to explain what's going on and the history of the vaccine? Do they need to see some different stats and numbers from, a different organization and stop getting some of their, their news, COVID news off Facebook or Instagram or Twitter? How can we help these employees make the decision that's best for them, and what can we do with that information. So, maybe a newsletter, maybe it's a presentation, whatever that looks like. We want to make sure that we're making those people feel safe about their decision. If they're still not safe with that decision and they still don't want to do that and you're going to require it, okay, we might lose a couple of people, but there are some really great employees out there looking for a new job or looking to rejoin the workforce. So, it will suck, absolutely, because you're going to lose some good people potentially, but you can also gain some people who are going to be on the same side as you and who are going to continue to promote that positivity that you want to keep going. Oops. Yeah, so that is actually the last slide that I have. Look at that. So I think it's just all about, and this is the same with any type of policy or procedure or anything new that we bring into the workplace. You know your employees better than anyone because you're with them. You spend a lot of time with them. So you know probably which ones are going to accept this, which ones are not, which ones are having difficulties with this already. And those are the ones, obviously, that we want to work with and talk to and see what we can do to help them out with this decision and let them know, this is what we're going to do. And maybe some of our employees will need, maybe we need a 60-day implementation in order to, get some of our team around this, whatever that looks like. So we need to set the expectations. We need to put everything in black and white for them so that they can read it and understand it, take it home if they need to, review it, whatever they need in order to feel safe. I don't like to pressure people to sign policies that day. I like to give them an opportunity to take it home, to review it. If you have someone who doesn't have a high literacy rate, they may feel more comfortable having someone else at home explain it to them. So you may want to take that into consideration as well, and don't force that signature right away. So set those expectations, let them know what happens if they don't get vaccinated. And if you are going to, offer some sort of an incentive to get vaccinated, again, put that in black and white, let them know, put those deadlines around that. Just make sure everything's written down and everybody's signed off on it and you apply it equally, and you should be relatively good. We haven't seen a lot of this stuff go through the courts. And as Drew said, that's how we tend to form a lot of our decisions going forward, is how the courts decide, and human rights will make some decisions on what's acceptable and what's not. And that will definitely help. The other thing is, we know that this is changing daily. Drew and I met 2 weeks ago to discuss this presentation, and we both said, yeah, I don't want to get ready until it's almost the day of the presentation, because we know that this is an ever evolving situation. And so I think that as a business owner or a manager, that is something to keep in mind, right? This is an ever evolving thing. In 6 months, the government may say, you know what? Yep, it was all a hoax and we're just joking and you don't need to worry about this. I don't think that's going to happen, but you never know what's going to happen 6 months down the road. So just be prepared for more changes going on. So that's all I had for today. Any questions?
Thanks for that as well, Jen. That was very informative. Does anybody have questions for Jennifer?
I do, Hetty.
Go ahead, Barry.
Thank you, Drew and Jennifer, for great presentations. One of the things I was going to ask you about regarding new hires and timelines, when you're posting for a position, should you be declaring your policy regarding vaccines? I know that it's not, you don't want to put negative things when you're trying to attract somebody, but should this be posted, do you feel, in an ad when you're hiring someone?
I do actually. If you had asked me that 2 months ago, Barry, I would have said absolutely not. And 2 months ago, we were telling people, don't ask that in interviews, don't bring it up, don't go there. But I think now with the changes that we've got with the federal government pushing down, with AHS and everyone else, I think it probably is okay to now put it in your ad, just one of those little lines at the bottom that, we do require our employees to be vaccinated. And then, we are able to accommodate for those with exemptions, and then just leave it at that. Yeah.
Yeah, I agree. The only risk in that is that decisions in hiring can also be discriminatory for human rights legislation. So it creates some smoke saying, okay, well, this is potentially, we're not going to be hiring people with disabilities or with religious beliefs that would prohibit them from being vaccinated. If you are referencing the fact that the accommodation is available, then that risk is pretty negligible.
Awesome, thanks.
Okay, next question in the chat from Tracy Daw. Are there any thoughts on booster shots in a policy?
I think, I don't know a lot about the booster shots at this point in time, Tracy. I'll be honest, I haven't looked into it. But I would think that if that is one of those things that becomes necessary, and if they are, the government's saying, yep, you're going to have a booster in order to be, completely vaccinated, that's something that you may need to add to it. Personally, sorry, I apologize. I'm not entirely sure if all of them need one at this moment in time, or if it's more of a down the road type thing that you want to add in.
Yeah, it's just a factor in the reasonableness of the policy. So all of the stuff we've talked about is part of what's relevant is the policy reasonable. And the reasonableness for things like that is really, we're going to have to defer to the public health experts. Neither Jennifer nor I know enough about that to give you good advice. I could imagine a situation where yes, it is going to be required, and certainly if it's a client thing, it's reasonable for your business. If your clients are requiring it, then okay, you're going to need to implement it to meet their requirements. But absent that, it's going to be, what is the general consensus of the public health community.
Okay, next question. Ken with GPRTA said that he heard that if you have implemented a COVID vaccine requirement for your staff and they end up getting sick as a result of that vaccination, does that become a WCB issue?
I don't know.
Yeah, I'm just thinking about that too. So I suppose it might. I know. Yeah, I mean, I think take this with a grain of salt. My gut, I'd have to review it to be sure, but I think it probably would be something that WCB would be willing to accept, which is probably good ultimately for the employer. One of the trade-off with WCB is if your injury is accepted as compensable by WCB, you don't have a cause of action against your employer. So if I'm injured in the course of work, in most cases, I can't sue my employer for that. So if it was something that WCB accepted, then that's great. Maybe your premiums go up a little bit, but you're not facing a civil lawsuit for this vaccine requirement, which potentially could be a thing. I know that again, that's an area of the law where it's not entirely clear. Like if you force someone to, force, but as a condition of employment, you require someone to be vaccinated, and they do have an adverse effect. Is there any liability for the employer tied to that injury? I would say it's going to be a pretty tough argument, in my opinion. Likely a stronger argument against the province or the health authority. But in any event, if it is accepted by WCB, the Workers' Compensation Act eliminates any cause of action that might exist.
And I'm sure the WCB is looking at that on a case-by-case basis if it does happen, because there would have to be a very strong correlation between the person getting vaccinated and proof that it was from the vaccine, and not just something that was already within their body, within the works.
So would that go with other vaccinations as well? Because people react to other vaccines. And just because, say, a measles, mumps, rubella, or a tetanus booster or flu shot, people react all the time. So would you have to specifically have vaccines as a policy for it to be a WCB thing, or could it just be somebody throwing that out there?
It'll come down to the WCB policies. So on the WCB Works website, pardon me, they've got a whole bunch of policies explaining when things are work related, and they'll interpret those with reference to the the circumstances of each case. And then there's also a body of tribunal decisions. So if you're denied WCB, you can appeal, and the appeals are reported in CanLII. Actually, you can look them up. So that would be the body of law that would help to interpret whether it's going to be compensable by WCB. And I would have to do a lot of research to give you a more informed opinion. I'll say it's possible, if it is related closely enough to the work, it is something that WCB might cover.
Okay. Does anybody have additional questions, or did Jennifer and Drew explain everything in layman's terms that we can understand it quite easily? If anybody does want their contact information, you can just email me and I will share it with you as well.
There's another question, Hetty, in the chat.
Oh,
Yeah.
okay, sorry.
So the question was about pending human rights or wrongful dismissal cases in the courts. I guarantee there are. I'm not sure of any good ones to look at going forward. Definitely, if you keep your eyes peeled on to the news, when something is going to, like, the Supreme Court, for example, you'll see that in your news feeds, I'm sure. But yeah, there definitely are. I mean, I've spoken to a lot of people that wanted to bring those claims. I don't have any that I've taken on, but I know there are some lawyers in Edmonton and Calgary that have sort of championed those causes, and there will be cases for sure. Apart from other questions, a couple of things that Jennifer mentioned that I really wanted to agree and emphasize. So maybe I'll take this opportunity to do that. The timing of things is important. Jennifer mentioned, duress, and someone can feel pressured once they've quit their other job to agree to whatever's been put in front of them. The timing is also important to have an enforceable contractual term. So I won't nerd out too much about how contracts are formed, but one of the things that you need for a binding contract is consideration. So something of legal value. In the employment context, that's usually work, the opportunity to perform work in exchange for compensation. The courts have said that in most cases, continued employment is not valuable consideration. If you're already employed, to say we're not going to fire you if you agree to this is often not going to be valuable consideration for the purposes of creating a contract. So it's important to communicate the terms of the contract beforehand so that people aren't agreeing to things down the road after they've already been employed. And if they are agreeing to things then, there may not be valid consideration for those new terms, and a court might shut them down. So yeah, really good to have things communicated ahead of time before the employment is accepted.
Okay, any other questions or comments from anybody? Going once? Okay, well, I would like to take this opportunity to thank Drew and Jennifer for all of their information, and we really appreciate you guys giving us this information from your professional standpoint so that we have a better grasp on what we're supposed to be doing within the workplace or with employees or potential employees, and know that things are changing all the time. So what was said yesterday might not be relevant tomorrow, but at least now we have some contacts and some context as to what things may mean in our workplace. So I would like to thank you both for presenting to us today.
My pleasure. And I'm going to run to a meeting, but thanks so much, guys. It was a pleasure to chat with you all. Take care.
Thanks, Drew.
Yeah, thanks for having me.